All right, y'all, it's a new year, and in the new year, I have made taking care of myself and my health a big priority. Trying to control my weight on top of having such a busy schedule has sometimes resulted in me eating overly processed meal replacements or heat and eat meals. Some of them may promote short-term weight loss, but it's not sustainable, and I know that I'm depriving my body of essential nutrients. They're often nutrient-poor meals that are made with cheap ingredients, chemicals, artificial preservatives, and additives. And there are GLP-1s that can be prescribed for weight loss, but medications can be costly and aren't always covered on insurance. Plus, they don't address the underlying causes of weight gain or teach you how to keep the weight off long term. They just rely on turning off the body's hunger signal, but that can end up preventing you from getting essential nutrients that your body needs and put you at risk for potentially dangerous side effects. Plus, you lose muscle along with the fat. But there's a healthier solution. Golo is a comprehensive weight loss solution that is safe, easy, and clinically proven to work. More than 5,000 doctors have recommended Golo to their patients. And by taking just 1 to 3 release capsules daily, you will quickly get control of your metabolic health within 30 days. Golo's Release is a natural supplement made of 7 plant-based ingredients and 3 key minerals that helps reverse insulin resistance, which speeds up the release of fat, and it naturally stimulates the GLP-1 hormone production to curb your appetite and balance blood sugar levels. My weight has fluctuated over the years, and there were times when I lost weight with some diet or trend, but I was really disappointed to gain it back. Golo can help with the underlying issues so you can keep off the weight. For a happier, healthier you, visit golo.com to get started on a more energetic version of yourself and enjoy 10% off. That's golo.com, code brandy10 for 10% off. Go to golo.com and use code brandy10 to join more than 5 million people who have switched to Golo as a better way to lose weight. Visit golo.com today.
The new developments in the Karen Reed murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Reed was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him? I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
and once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Reed. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Reed was drunk and reckless when she hit John O'Keefe.
It's not just Reed being sued here. The family also suing the 2 Canton bars from that night.
The 2 bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Reed is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they are coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Since the last episode was published, there have of course been some new filings and some new updates. Before we get into the second day of the hearing, where the defense is going to argue for dismissal based on governmental misconduct, I want to give some updates and rulings that have come out about some of the topics that we covered last week. First, let's start with Special Prosecutor Hank Brennan admitting that he was wrong. I played the clips last week of Brennan accusing defense attorney David Yannetti of making comments to Court TV that were really made on a Zoom meeting, and then he basically accused Yannetti of lying when he tried to correct the record. Well, Brennan filed an affidavit and a motion to correct the record. But let's take a look at it. Hank Brennan has proven to me that he can't be trusted. And now, because of his own actions, I scrutinize everything that he says and does. He's very calculated. Brennan says that in his oral argument, he gave a number of examples of extrajudicial statements that have been made by defense counsel, as well as examples of in-court statements made relative to the now closed federal investigation and the potential impact such statements may have had on the potential jury pool. So I went over my issue with the hypocrisy of this last week. Saying that you're worried about extrajudicial statements impacting the jury pool when the DA himself released a video to media to show the jury pool, it's disingenuous. Side note on this, lawyer Peter Tragos, covered this video from Morrissey in his latest podcast episode that just released this week. Now, I talked last week about the hypocrisy of it, but Peter actually breaks down the Massachusetts Code and how the video violates that in his latest podcast. I definitely recommend checking that out. So, aside from the disingenuous statement about being worried about the jury pool, I can't help but feel like the whole purpose of this was to have somewhere in writing that the federal investigation is now closed. I think that Brennan feels like this gives some credibility to his case. But that's not how I see it. The federal case closing doesn't mean that there were no issues found. It means that there wasn't enough found to prosecute anyone. Also, we still aren't even clear about the specific target and what came from it. Regardless, Brennan acknowledges that Yannetti's comment was an in-court statement, not extrajudicial. He says his mistake was unintentional and regrettable. I think it's good that he acknowledged his mistake, but I wish he would have acknowledged basically calling Yannetti a liar when he stood up and made his little comment about Court TV not being in the room. But I don't know, at least this is something. Next up, Judge Canton made her ruling on the sanctions and gag order request from the Commonwealth. Now, this was the argument that we went over in the last episode from the hearing on March 5th. Judge Canton says that Brennan asked to have the defense's motions sealed until he can review them and make sure that he doesn't want to object to anything before they become public. Now, he requested this because he claims that Yannetti purposely included the sealed text from Proctor in one of the filings. The judge's order says Yannetti acknowledged the text should have been sealed and it wasn't an intentional releasing of it. So she says that sanction isn't a proper sanction for an unintentional act. Now, Judge Canton did impose a gag order, though. She said, based on the interviews that were done and defense counsel's, quote, consistent, publicly reported interactions with reporters and bloggers throughout the first trial, end quote, she agrees with Brennan that an order limiting extrajudicial statements of counsel is appropriate and necessary to ensure a fair and impartial trial. Now, the judge said that in an interview with Gretchen Voss, Karen Reed said something about the bartender at Waterfall testifying in the grand jury. And she later said what the bartender said. So grand jury testimony is secret. And she says that attorney Alan Jackson was with Karen during the interview and did not stop her from saying something about that testimony. The judge also says that in the interviews, Jackson referred to a couple of the witnesses as liars, and she says that Massachusetts law says an attorney can't comment on the character, credibility, or reputation of a witness. Basically, they can't do any of the things that DA Michael Morrissey himself did in his video. So the judge ruled that no attorneys appearing in this case can release or authorize the release of info about the proceeding that would be prejudicial if potential jurors heard it, and they can't release any info that would be inadmissible as evidence. We also have an update on attorney Mark Betterow joining the defense team. Brennan said he didn't object to Betterow joining, but he wanted to be heard. Then he basically said he thinks that Betterow representing Aidan Carney would be an issue, so he wanted the judge to consider that. Now, the judge asked for another affidavit about Betterow from Yannetti, so he filed one. Yannetti said that the source of Betterow's qualifications and background came from conversations and information that he's provided, but he tells the judge if she needs more, Betterow is available to talk to her so that she can get what she needs from him. He also says Betterow has never been sanctioned or disciplined in any jurisdiction where he's been admitted to practice, and he's been doing this since 1998. He worked as an assistant DA in Manhattan, which is one of the largest and most prestigious prosecutor's offices in the U.S., and he has practiced criminal law and has his own criminal defense firm in Manhattan now. So all of this is great. Betterow is an amazing attorney. But, of course, Brennan's issue was with Betterow's representation of Turtle Boy. So in the new affidavit, Yannetti says that Betterow conducted separate and extensive discussions with Karen and Carney, aka Turtle Boy, reviewed the rules of professional conduct with them, and had each of them talk to their other attorneys to discuss this before they agreed. They both did agree and signed waivers. So here's where the potential issue comes in. There is sealed and protected evidence in Carney's case, and there is sealed and protected evidence in Karen's case. So if Betterow is an attorney for both, he would have access to both. The affidavit from Yannetti says that Betterow has never shared any of the privileged info in Carney's case with Karen or her attorneys, and he won't share any protected material provided to him on either case. He's going to do what he's supposed to do as an ethical lawyer and kind of put a wall up between the two cases. So the judge issued her ruling on this, and she actually denied Betterow joining the defense team. Her reasoning is that the affirmation that Yannetti submitted isn't good enough, and she says that the conflict of interest can't be waived based on Massachusetts rules of professional responsibility. Now, the rule that she lists here states that a lawyer can't represent someone if it's a conflict of interest. And a conflict of interest is when representing one client will be directly adverse to another, which doesn't seem to be the case here. Or if there is a significant risk that your representation of one of the clients will be materially limited by responsibilities to another client. So if representing one will somehow make you not be able to represent the other the way that you should. Now, the rule says that if you can provide competent and diligent representation to each of them, and they don't have claims against each other, then the lawyer should be able to represent both. Now, if their testimonies conflict with each other or their interests conflict, then the judge can basically shut it down, even if both parties consent. Now, it's hard for me to understand being able to deny this when I'm reading that rule, especially when the Commonwealth didn't even have an objection. This is just the judge saying no. Judge Canoni says that by Betterow promising to restrict his use of certain information, as in not using the discovery from one case for the other, that he is proposing to ignore information known to him through his representation of one client, even where the information might benefit his second client, and she won't permit such conflicted representation. That just seems so weird to me. To deny this based on potential future conflicts, if Betterow gets material from one case that's relevant to the other case, he'll end up getting it in the other case anyway as discovery. And if it's not relevant, it won't matter anyway. Finally, Judge Canoni says that she won't add to the defense team that currently has at least 4 lawyers. 3 by admission pro hoc vice. Now, that's interesting. I can only assume that this is all about the records that the Commonwealth is asking for in relation to Carney's case. I mentioned in the last episode that Brennan wants phone records from Turtle Boy's case because he says that those are relevant to this case. But he doesn't want the defense to have the records in Sandra Birchmore's case because he says those are not relevant to this case. I don't know how that makes sense. I'm not an attorney, obviously. The whole point of this podcast is to weigh the evidence and look at things from the perspective of a juror. Although I do consult with a lot of attorneys on different legal aspects of things when I need to better understand them to break them down for these episodes. This is one of those issues that I wanted a legal perspective on. So I talked to 2 attorneys, and I also checked out some of the reactions of other attorneys that I trust to hear different perspectives. Attorney Andrea Burkhart is an experienced trial and appellate litigator. And having experience with appellate courts, she had a very interesting perspective on this decision. Burkhart says that excluding Betterow from joining the defense team could be a potential basis of appeal in the event of a conviction. She described it as the holy grail of appealable issues since it would be considered a structural error. Now, Burkhart says that the Massachusetts rule of professional responsibility actually contradicts the judge's decision. And Judge Canoni didn't provide any factual basis for why she determined the defense didn't satisfy that rule. Burkhart says that denying Betterow represents a significant overstep of judicial authority. She discussed a Supreme Court ruling that basically says if a trial court abuses their discretion in deciding a pro hoc vice admission question, it's depriving the right to counsel, and that results in an automatic reversal if convicted. Hearing this from an attorney who has done appellate work is really interesting to me. Definitely something for us to keep in mind for what may come in the future. We'll be right back after this. Who doesn't love the good things in life? And even though I enjoy a little luxury, it doesn't always mean that I can afford it. That is until I discovered Quince. Quince is my go-to for luxury essentials at affordable prices. Quince offers a range of high-quality items at prices within reach, like 100% Mongolian cashmere sweaters from only $50, washable silk tops and dresses, organic cotton sweaters, and 14-karat gold jewelry. That's one of my favorites. The best part, all Quince items are priced 50 to 80% less than similar brands. By partnering directly with top factories, Quince cuts out the cost of the middleman and passes the savings on to us. And Quince only works with factories that use safe, ethical, and responsible manufacturing practices and premium fabrics and finishes. I love that. Some of my absolute favorites from Quince are my aviator sunglasses that I get so many compliments on. And I love their 100% European linen fit and flare midi dress. It's perfect for spring and summer or worn with one of their cashmere sweaters in the fall. Give yourself the luxury you deserve with Quince. Go to quince.com/brandy for free shipping on your order and 365-day returns. That's QUINCE.com/brandy to get free shipping and 365-day returns. Quince.com/brandy. So now, let's get into the motion to dismiss. This is the big one. There's a lot to go over here. And rather than just do a recap or a summary in chronological order of who said what, I want to break this down into the main issues here so that it's easier to understand. So you'll remember that we went over the motion to dismiss in a previous episode. Now, the main issues that the defense listed were destruction and withholding of evidence, as in the Sallyport videos, and withholding statements made by Jen McCabe. They argued that these are discovery violations and constitutional Brady violations. The other main issue was the juror that was dismissed. Now, I'm not going to go back over the written motion and the argument that we've already been over, but since those motions were filed, more information has come out, and it makes the situation a lot worse than it was before, and gives the defense's motion to dismiss a lot more weight. Let's start with the Sallyport videos. There is absolutely no argument that there are discovery violations here. That's not disputed from either side. The issue is whether or not those discovery violations meet the legal standard to be considered prejudicial against Karen Reed. The defense says it does, and says that evidence was intentionally withheld from them during the first trial. The Commonwealth basically says, yeah, we should have turned it over, but we didn't even know it was there, and it was just an oversight that it wasn't turned over. So let's take a look at the timeline. January 29th, 2022, Karen's car is brought into the Canton PD Sallyport. We were told by Brennan that all the footage of this happening will be overwritten within 30 days, right? Which would mean it would have been overwritten after February 28th. The video footage that's handed over is given to the defense on April 4th of 2024, which is more than 2 years later. Then more on April 23rd of 2024 during trial, then more in October of 2024 after the trial, and then even more in January of this year. Now, in their response to the defense's motion to dismiss, the prosecution basically just kept saying, well, we didn't know it was there. We didn't know it existed. So, does that matter? That they didn't know? Well, remember, Lally signed a certificate of compliance that they had turned over all evidence after inquiry to the investigators and everyone involved. So, does that make this more of a big deal, less of a big deal? Or does it matter that the Commonwealth is saying that they didn't know? Well, here's Judge Cannoni's own words.
You all know that when one of you speaks, you speak for the entirety of the team. When one of you acts for the entirety of the team. And when one of you makes representations or misrepresentations, you speak for the entire team. We didn't know that. So each is legally accountable for the actions and statements of the entire team.
I wish I could say that those words were spoken to the Commonwealth about the misrepresentations that were made. But that doesn't seem to really happen here, does it? The Commonwealth gets to pretty much do whatever they want, and I haven't seen any reaction like this from Judge Canoni toward them. These were her words to the defense 24 hours earlier. I actually edited out the word defense before team. But the legal standard here is the same, and it's even a bigger deal for the Commonwealth. So will this same energy from the judge be applied to the Commonwealth's misconduct? So far, it's looking like that's a big fat no. The investigators and police and Proctor, all of these people are considered agents of the Commonwealth. It doesn't matter if Lally didn't know. What matters is that law enforcement knew and did not turn it over. Now let's break down this messy Sallyport video situation. First, let's talk about why having this footage matters. It all comes down to the condition of the taillight. Attorney Alan Jackson argues that the condition of the taillight when it came into the Sallyport is critical. Why? Because their theory is that Proctor had access to the taillight, and where it was cracked and missing a small piece, he or some law enforcement officer present was able to break the taillight more, causing it to appear the way that we saw in the photos that were taken days later, where almost the entire outer lens is missing. Now, if they can get any kind of clear footage of her taillight, where it's only missing the small piece when it came in, instead of being completely destroyed, then it would exonerate Karen. So, of course it matters. Now, Jackson also argues that the prosecution knew that the videos would impeach the lead investigator on the case, showing that Trooper Michael Proctor was not telling the truth. The bottom line is the videos should have been turned over to the defense, and they weren't. That's a discovery violation. But now, the judge has to decide if this is more than just a discovery violation. And in order to decide that, there's a lot of questions that need to be answered. There are some things that we learned in this hearing that we didn't know before. And I'm going to walk through the timeline and break down the different things that we learned and why they matter so much. A lot of what we're now hearing is really bad for the prosecution. And I think that Brennan knows that, because his entire demeanor as he's having to explain the timeline to the judge is totally different than the dramatic, accusatory snark that we're used to with him. But don't worry, the dramatic, accusatory snark comes back after he's done having to explain how bad they messed up. But buckle up, y'all, because this gets wild. Let's start from the beginning. We know that Karen's SUV was brought into the Sallyport on January 29th, 2022. Here's Brennan explaining to the judge what happened next.
What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor.
Here's why this matters. This proves that Trooper Proctor knew that the Sallyport video evidence was important and relevant. No matter how many times Brennan argues that it didn't have relevance, the lead investigator requesting it immediately shows what the rest of us who aren't in denial already knew. Of course it's important in a murder trial to have a video of what you're alleging is the murder weapon being brought in to a police department that's conflicted out. So Proctor knows it's relevant, and he requests it right away. But here's the worst part. At some point, Sergeant D.G.M. Petro downloads the video, all of it, in 6-hour segments because there's so much and the files were too big, so he had to break them down. Now, here's why this matters. It doesn't matter if the video footage overwrites in 30 days. We now know that they have a complete download of every minute that the car was in there, broken up into 6-hour segments. So, where is it? Why is the defense being handed small clips here and there when we know that they downloaded everything now? And why has Brennan spent so much time arguing about preservation orders when it was preserved all along? Think about how much this changes everything that we used to know. Proctor put it in 9 different reports that he got Karen's car from her parents' house at 5:30. They fought the defense on that for 2 years, even trying to say that they didn't account for daylight savings time. Finally, their excuse evolves into a scrivener's error on all 9 of those documents. Getting the car at 5:30 would have meant that there's no way to get taillight to Fairview Road by 5:45. But they didn't get it at 5:30. They got to Canton PD at 5:30. And for 2 years, while they argued with the defense about that, they had video evidence in their possession that proved that the car arrived to Canton PD at 5:30. So Buchanan says in his report from just days before this hearing that he was made aware sometime in spring of 2022 that Proctor wanted this footage. So he goes to Canton PD and picks up the video footage that's left on a desk for him, and he takes it to Proctor. Now, did Proctor enter it into any evidence log? Of course not. He just held on to it. And because there's no record of it, we have no way of knowing where it was or who else had access to it or what, if anything, was done to it. Now, we'll call this video collection 1, the blurry video that is missing time. Fast forward to 2023. The defense has come out with their theory, and the Massachusetts State Police are in the hot seat. So now Proctor makes a second request for different cameras. He wants the views outside of the Sallyport that would show that the tow truck dropped the SUV off. And he calls Canton PD, and Sergeant D. Giampetro doesn't tell Proctor, "Oh, I'm sorry, that overwrites after 30 days. Nope. What he does is make another big download for him with the angles and cameras that he asked for. Now, can anyone explain how he was able to do that almost a year and a half after it's supposed to have been overwritten? No, that's why we need an evidentiary hearing so that these questions can be answered. So, in July of 2023, Buchanan is made aware that Proctor had requested more footage and he needs to pick it up. The sergeant leaves a CD at the front desk with a post-it note that had Buchanan's name on it and the January 29th date. So Buchanan swings by on his way to work and picks it up and then takes it to Proctor. We'll call this one Video 2, the driveway. So 8 months later, there's a federal grand jury and Proctor is testifying. He says that he has seen all of the Canton videos, but it's been a while since he saw them. Well, this is news to Lally. He sees Proctor's testimony in the transcripts right before trial, and he's like, "Hey, Proctor, WTF?" So he asked Proctor for whatever videos he has. Now, Proctor is at this point in possession of what we know anyway, Video 1, the blurry video that's missing time, and Video 2, the driveway. But when Lally asks him, Proctor only turns over Video 1, the blurry video that's missing time. So Lally files a certificate of compliance that everything has been turned over. Everything that they have, the defense has. And then 2 days later, Yannetti says in court that the video footage at Canton PD is missing 42 minutes at the precise time that the SUV is brought into the Sallyport. Convenient, right? Well, Tully reached out to Chief Rafferty, and she reviewed the video that the defense still hasn't been made aware of, where the SUV is arriving at Canton PD, and she told Tully that it does exist and that they should have it, despite what Yannetti said. So Tully gets the video because obviously it still isn't overwritten, and the Commonwealth and their agents can access it whenever they need to. And it's turned over to Lally, who then turns it over to the defense during trial. This is Video 3, the inverted video. Also during trial, Chief Rafferty and Sergeant D. Giampetro talk about the defense and decide to pull more video in case they need to fight the defense's claims. Now, they end up pulling the videos that have Higgins on the phone and moving around the cars right after John's death. This is Video 4, the Higgins videos. Now, these are not turned over when they're produced during the trial. They don't make it to the defense team until October. But the defense isn't really told anything about how or where they came from. They weren't turned over like they're supposed to be. They weren't even downloaded because of their discovery obligations. No, none of that was done for any of the right reasons. This wasn't about discovery obligations. They only downloaded this so that they could protect their own reputation. This sergeant and the chief of police are strategizing on how to defeat the defense, but never turned over the video. And miraculously, They were still there this long after 30 days.
That brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, "That is how it records, LOL, no tampering," end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations.
A notepad with LOL is not what I would expect from the chief of police. But let's keep going because this gets worse. Now, after the trial in July, Colleen Crawford from Norfolk District Attorney's Office goes to Canton PD to look at their DVR system. Now, of course, there's not going to be anything there because it overwrites after 30 days, right? We know that because Hank Brennan already told us that in a previous hearing recently. So we can assume that there was nothing there, right? Wrong. Here's Brennan walking back that argument that he so strongly made before.
After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sallyport and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial.
Oh, how very interesting. So there were multiple backups. So the video evidence was still available right there at Canton PD the whole time. How very interesting. But yet it wasn't turned over. So Colleen Crawford from the DA's office is able to access all of the video footage in July of 2024. Then the following month, the video of Higgins with the LOL note is turned over to Brennan. And then Brennan, who has an ongoing discovery obligation to turn things like that over, waits 2 months before turning that over to the defense. So they receive that video in October. Then 2 days later, Sergeant D.G. Petro retires. The following month, they begin trying to work out sending an expert out to Canton PD to access all of this video footage that Colleen Crawford said was still there and see what metadata they can get from it and what's available, what they're missing. So the expert flies out in December. And then, poof, the video that was available on the backup hard drives for this murder trial after 30 months was somehow overwritten after 35 months.
And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing.
What are the odds? So Colleen Crawford, who had just accessed the video in July, had also talked to the defense and knew that their expert would be coming to get the video. But somehow she acts surprised to see the expert when he arrives. And now there's no video and they won't give the copies that they have to the expert. They're telling him to get them from the defense. Well, if the defense had them, they wouldn't have flown out an expert. The defense is only given scraps when the Commonwealth and its agents want them to have it. Somebody from the Commonwealth knew that the videos were overwritten within 30 days. So somebody has had those videos all along and did not turn them over, even when the defense sends their expert out there. That is the kind of bad faith that Jackson says supports the motion to dismiss. So after this, Brennan goes up there to Canton PD, and the sergeant, who retired 2 months earlier, tells him that he would click and drag copies of video when he would download them from the DVR. Now, Brennan ends up asking everyone for any videos they have. So the following month, on January 27th, Tully hands over video that we are told was in Proctor's file. This is video 2, the driveway. So now it is 2025, and video evidence is still being handed over in little clips here and there. But there have been no 6-hour segments, no clear videos of when her car got there and what condition it was in, and no explanation about why everyone can apparently access the videos at any time except for the defense, because they're told it's overwritten after 30 days. So who knew what and when? Who knew that this video footage was being withheld from the defense? That's an important question here. There's so much confusion over the video footage because it was not handled properly. There were no evidence logs done. Nothing was turned over when it was supposed to be. It was all pretty much just the Commonwealth and its agents doing what they want when they want. So let's look at Buchanan. What did he know? The report that he did just days before this hearing apparently explained the general timeframes of when he was told to go get video, stuff like that. But he says that he didn't review any of it when he got it. He just took it to Proctor and dropped it off. His report also says that in May of 2024, the trial is happening, and then that's when he receives a thumb drive and a CD. But he doesn't say where he received it or who he got it from. We don't even know if it's the same CD with the Post-it note, because apparently this one's labeled differently. There's no chain of custody for literally anything. So was it the same? Was it different? Who had it? Where'd it come from? If this had been admitted into evidence with a chain of custody like it's supposed to be, instead of a Post-it note, maybe they would know. So what did Buchanan know? During cross-examination, Buchanan said that he had reviewed some video with Lally before his testimony, but he said he couldn't exactly remember which ones he had watched. But Jackson says that now, in his report, Buchanan admits that it was exterior Sallyport video.
We now know that Buchanan watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing, because we didn't have the videos. So either they reviewed together the inverted video that was then played, and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally.
So, in May, when he's reviewing this video footage with Lally, the only footage that has been turned over to the defense is the camera from inside that's missing time, and now the inverted video. So if Buchanan is now saying in his report that he reviewed exterior Sallyport footage with Lally, then that could be really bad. And what about the man at the center of all of this? Proctor. What did he know? Proctor was receiving the video, and he's the one who was requesting it. And he may have been the one who gave it to Buchanan and all of that to review, but we don't know because there's nothing in any reports. All of these other questions need to be answered. They need to have an evidentiary hearing. Jackson points out that Proctor said on the stand that the Sallyport video that they had recently received and that they were discussing had been discovered later and handed over. But Jackson points out that had he known everything that had happened, he would have been able to impeach Proctor on that testimony. There's no way for that video to have just been discovered later. It had to have been downloaded in February if it overwrites in 30 days. And he obviously knew it existed because he's the one who asked for it and received it. And even when Lally came to him and asked about the video because of the grand jury testimony, he, an agent of the Commonwealth, still only turned over some of it, keeping some of it in his possession without telling the prosecutors. The prosecutors are all saying that they weren't given these videos, but we know that Proctor requested them and that he had them in his possession. And if that's true and the prosecutors did not have them and didn't know that they existed, that means that even after he was asked to turn over everything, Proctor withheld evidence. And that is the definition of bad faith, according to Jackson. During trial, they could not impeach Proctor with this because all of this was withheld from them. There are a lot of questions about this left unanswered right now. Like, why did Colleen Crawford get everything on the backup hard drives, but then the expert couldn't get everything from the backup hard drives? And how come everybody can get video anytime they want except for the defense? It sounds a lot like destroying evidence. And also, why would Brennan think that the videos may no longer be there if they were just there when someone from the DA's office went and it was still there on the backup hard drives? The only way to be able to get answers about who knew what and who did what is to have an evidentiary hearing. Call these people to the stand. This is not how trials are supposed to go. We'll be right back after this. All right, y'all, it's a new year, and in the new year, I have made taking care of myself and my health a big priority. Trying to control my weight on top of having such a busy schedule has sometimes resulted in me eating overly processed meal replacements or heat and eat meals. Some of them may promote short-term weight loss, but it's not sustainable, and I know that I'm depriving my body of essential nutrients. They're often nutrient-poor meals that are made with cheap ingredients, chemicals, artificial preservatives, and additives. And there are GLP-1s that can be prescribed for weight loss, but medications can be costly and aren't always covered on insurance. Plus, they don't address the underlying causes of weight gain or teach you how to keep the weight off long term. They just rely on turning off the body's hunger signal, but that can end up preventing you from getting essential nutrients that your body needs and put you at risk for potentially dangerous side effects. Plus, you lose muscle along with the fat. But there's a healthier solution. Golo is a comprehensive weight loss solution that is safe, easy, and clinically proven to work. More than 5,000 doctors have recommended Golo to their patients. And by taking just 1 to 3 release capsules daily, you will quickly get control of your metabolic health within 30 days. Golo's Release is a natural supplement made of 7 plant-based ingredients and 3 key minerals that helps reverse insulin resistance, which speeds up the release of fat, and it naturally stimulates the GLP-1 hormone production to curb your appetite and balance blood sugar levels. My weight has fluctuated over the years, and there were times when I lost weight with some diet or trend, but I was really disappointed to gain it back. Golo can help with the underlying issues so you can keep off the weight. For a happier, healthier you, visit golo.com to get started on a more energetic version of yourself and enjoy 10% off. That's golo.com, code brandy10 for 10% off. Go to golo.com and use code brandy10 to join more than 5 million people who have switched to Golo as a better way to lose weight. Visit golo.com today. Aside from who knew it was being withheld from the defense, and aside from the nonstop discovery violations and lack of chain of custody and no reports and nothing being handled properly, there are issues in question about all of this. Now, a lot of discovery violations can be salvaged by just handing over the discovery for this trial. But if not having that evidence during trial caused prejudice against the defendant, that's a different story. In that case, it's not enough to just turn it over now with a note that says, LOL, oops. So Brennan argues a lot that there is no tampering with the evidence and no altering the evidence. But Brennan says a lot of things that turn out not to be true. And also, how does he know? How does he know it hasn't been altered since they were never given original copies and there's no metadata and there's no chain of custody? You can't guarantee that. You can't guarantee that they haven't been altered because nobody did their job right and you don't know. The prejudice here is that you can't undo that now. It's too late. There's no way for the defense to forensically verify any of this. So they can't prove anything. They can't prove that it is or is not altered. They can only show that it's altered because at some point, somebody took a set of 6-hour videos and turned over just small clips here and there. Also, Jackson points out that the Commonwealth and its agents were in possession of video evidence from multiple cameras in 6-hour segments. Yet, the defense is only handed over these small clips here and there, none of which show what they need it for, which is just the taillight. They just need the condition of the taillight. That many cameras in that much time, and nobody can even get one of those clips to show what the defense is asking for? Jackson says at some point it defies logic that all of the clips that they're provided are basically bad enough quality that you can't even really see anything. Or they're missing the time, or they're super clear, but it's inverted and you can't see the side of the car that you need to see. Brennan says that that's how the video is recorded, grainy and bad quality. Okay, but how do you know? How do you know? How do you know if nobody has the original? Could the way that they transferred them make them lose quality? Or did someone do something to them? How can we ever know since nothing was done properly? You can't present that as fact and have nothing to back it up or show proof. And another thing that came up is that apparently Louis Jutros was involved in Canton PD police video as well, instead of just the Canton library video. Now, the defense was never told anything about that, so they didn't get the opportunity to cross-examine him on any of that. And we also hear now that Jutros apparently went to the Sallyport and replaced the only clear camera, the inverted one, because it was defective. Now, when was this done? Well, of course there's no date given. We're only told that it's sometime between January 29th, 2022 and July of 2024. So he goes and replaces that camera, disposes of it, and now, surprise, surprise, we have no way of testing the camera to even see if it's recorded inverted. It's destroyed. Now, the Commonwealth did show a video from before when it was inverted, but how did they get that? Where did that come from? It was from before January 29th of 2022. So how did you get that video if it records after 30 days? Jackson points out that the Commonwealth says that they are equally aggrieved because of the bad quality of the video. Now, aggrieved means that they were wronged, so basically Brennan is admitting that the defense was wronged because of this. It doesn't matter if the Commonwealth thinks that they are wronged. They're not the ones on trial. This was a close case because the jury voted in favor of Karen on 2 of the charges, and they were hung on the lesser charge. And now we will never know what they would have done if they had had all of the evidence. Now, it may come as a surprise to literally nobody that Brennan's arguments on this were all big misrepresentations, some that he presented as fact with no evidence or exhibits to back them up. Let me channel my inner Bob Alessi and list out some of the misrepresentations from Brennan on the condition of the taillight not being an issue. 1, he said in his response that the Commonwealth turned over about 90 pictures of Karen's taillight to the defense. What he doesn't mention is that all of those pictures were from days later. Those are completely useless in this argument. And Brennan didn't put the date of those pictures that were taken in his motion because he knew that those pictures had absolutely no relevance. 2, Brennan says that the CERT team was already on scene before Karen's car arrived at the Sallyport, and he mentioned the 2 CERT team members who were there. Now, Brennan knows he is once again arguing half the information in order to mislead, because we all know that Karen's car arrived at Canton PD at 5:30, and the last CERT team member didn't arrive at Fairview until 5:41, and the first taillight piece wasn't found until 5:45. But he leaves that part out. And the reason he leaves that part out is because he knows that those times support the defense's theory, not his. No taillight was found until after Karen's car arrived, and Proctor and others had access to it. Then 15 minutes later, right down the road, the first piece of taillight is found and is placed on top of a pile of snow to take a picture of it. 3, Brennan says that the defense is claiming the condition of the taillight is important because of this.
The defense's argument is that this evidence, this information, is exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece.
Now, this is obviously yet another big misrepresentation because there has never been one time that the defense has claimed that. In fact, their entire theory has always been that the taillight was missing a piece because they believe it was broke when she backed into John's car in the driveway that morning. I'm not even going to bother with clips of this to prove Brennan wrong because there are way too many clips of them saying this. And it's common knowledge. It's been their position on this the entire time. In fact, Brennan even brings up Karen's interview with Gretchen Voss, where she tells Voss that when her car was seized, there were a few small pieces of the taillight that had collapsed into the light housing. And she said that she stood in the driveway at John's at 5:45 that morning and picked those small pieces out, dropping them in the driveway and telling Carrie Roberts and Jen McCabe, "Look what I did to my taillight." Now, why would she tell a reporter that if she was claiming that her light wasn't broken? Brennan just makes stuff up. Also, remember that when they put the taillight back together during trial, they showed this, it was missing a piece, so her story checks out. Now, he also shows a video clip where he explains that the taillight is destroyed already, and he claims that you can tell because you can see white. Now, he says if the red taillight cover is missing or gone, the white bulb shines, and that's why he says it looks white right there in that video clip. But I don't think he checked that out. There's an interesting video that has been circulating where a man shows how the taillight of the Lexus SUV actually lights up. And what's interesting is that even when every piece of the red from the taillight is removed and all you see is white everywhere, no red at all, when it's dark outside and the taillight comes on, it doesn't shine white like Brennan said. It shines red. Something else that was really interesting is that the piece of taillight that Lally described as having dimples with the raised areas on it, and they're trying to say that that's what caused the abrasions to John's arm. In that video, when that piece is broken out, the taillight didn't illuminate down the side at all. The video is on YouTube channel called Be in Trouble 31. Letter B, letter N, Trouble 31. He takes a hammer to begin breaking the taillight to do some experimenting with it. And it takes a lot of force to break it. He holds up the pieces sideways too, and you can see how thick they are. I don't know how they believe an arm could break that polycarbonate. Now, the chrome divider piece, that was broken on Karen's car, and apparently it's really strong. An arm couldn't break that. He had trouble getting that with a hammer. There's a lot more to this, and I really recommend checking out the full video. It's very interesting. But for just what we're looking at here, what Brennan explains about the light just isn't true. So let's keep going with the list. Brennan says that Dighton Officer Barrow's testimony says that he saw the taillight broken, not completely damaged, and a piece was missing. Now, remember, the defense didn't bother cross-examination on this because the way that Barrows described it is exactly the condition that they have said that the taillight was in at that time all along. But Brennan claims that this is a description of exactly how the taillight was when we see the pictures of her car at the Sallyport. That's false. The pictures at the Sallyport from 2 days later show the taillight almost completely missing. It's totally damaged. Most of it's missing. Number 5, Brennan brings up Lally asking the ARCA expert, Dr. Rentschler, about the video of Karen backing into John's car. And the expert says he's not seen it. Lally asks him if backing into a car at 0 to 5 miles per hour could provide the damage that he saw, and the expert said no. Now, Brennan says that this is evidence that the taillight condition is not in question. But this is yet another thing that he's spinning. Of course, a car going 0 to 5 miles per hour wouldn't provide the damage he saw. The defense has never said it did. They're saying that it provided the damage that was done before the light was completely shattered and almost all of it was missing. Now, had Lally asked, would 0 to 5 miles per hour cause a taillight to crack? Maybe that would be a more applicable question. So this is another misrepresentation. Number 6, Brennan spends a lot of time arguing that the defense didn't include the Sallyport specifically on their preservation request. So he says that they can't be expected to have preserved it. He even argues in the hearing that it's not assumed that the Commonwealth will collect every video from every part of town during an incident. Now, here's why this is a red herring. Brennan is trying to put the blame on the defense for not getting this video evidence. But the preservation order specifics are now a moot point because we have now learned about all the backup drives. Yeah, in July of 2024, after the trial was over, Colleen Crawford saw that the video footage that we were told overwrites is still there. So Brennan spent all that time arguing that they weren't required to preserve it, and we now know that it was already preserved. They had it. They kept it. They just never turned it over. Let that sink in. Number 7, Brennan says that the video is not relevant material. He says that the Commonwealth only seeks material that's relevant, and when they receive it, they're supposed to provide it. Well, we know now that's disingenuous because we found out that Proctor, the lead investigator, knew it was relevant because he did 2 different requests to get Sallyport footage, each from different cameras. But what makes this worse is knowing that it was believed to be relevant enough to request it, and it wasn't turned over. 8. Brennan keeps insisting that there is no evidence that the video footage was altered or tampered with in any way. That's false. We may not know if anything was altered in a specific, intentional way, but the footage has definitely been altered in some way because the metadata is gone. It's not saved in its original form. The defense can no longer verify any of it forensically. And on top of that, the video footage that all still existed on these backup hard drives that we just recently learned about, all of that was there in July of 2024, right after the last trial. So the defense sends an expert out and suddenly it's gone. It was there for 2.5 years, not 30 days, and then a few months later it's suddenly gone. Plus, we know that there was 6-hour chunks of it that are now small clips. So it had to be altered in some way. Now, Brennan also makes a weird argument about how if the government was going to withhold evidence from the defense, that they would have not eventually turned it over. And he insists that this isn't exculpatory, and he insists that it's not Brady. And he also says that Proctor didn't withhold evidence. It was just an oversight. Now, Brennan basically admits that the production of the videos should have been sooner, and they should have been clearer, and there should have been an evidence log and a chain of custody. But he says the failure to do all of that was inadvertent. He claims it's unfortunate and it shouldn't have happened, but he says that it isn't Brady or exculpatory or intentional, and he basically just kind of blows it all off. All right, so now for our other big issue that was mentioned in the motion to dismiss, jury interference. So look, this is one of those arguments that is really hard to get to the bottom of because the jury stuff is so secretive. But there are a few things that we know. There are the actual legal issues here, and then there's the drama. Now, I want to separate those 2 issues so that the main issue does not get lost. Here's what the actual issue is. Someone told someone else who may have told someone else that there are rumors, not evidence at this point, just rumors, that a juror who seemed to be supportive of the defense was talking about the case in a bar, and someone may or may not have recorded it, but there was never any evidence of this, no video was ever presented, no affidavits were ever signed, and not even the name of the source given. This is literally just rumors. And those rumors were apparently reported to Trooper Fanning, of all people, Proctor's supervisor. Now, he was involved in the interviews of some of the witnesses. He was there when they seized Karen's phone, things like that. He didn't have a major role in the investigation, but he's just in the peripheral of it for sure. Now, he's also on the text thread where Proctor is texting his buddies at Mass State Police and saying, I was looking through Karen's phone and hadn't found any nudes yet. So classy. So someone who is not named tells Fanning about rumors, and then Fanning tells a court officer, the court officer tells the court, and the judge calls a sidebar with the attorneys. Now, the defense wants to know who the source of this information is, and the court officer who reported it comes up to the sidebar and tells them that Trooper Fanning told him that an unnamed source told him about the rumors. So they brought in the juror who denied it, and there was never any evidence presented, no affidavits, no recordings, no witnesses, no further discussion. There was nothing. The defense asked for there to be some kind of evidence presented of this instead of just rumors through the grapevine, but the judge said no. The defense objected, but the juror was dismissed anyway. Now think about that for a moment. This juror spent months in court and may have potentially formed an opinion based on her body language, and it was probably going to be a not guilty vote. Then unnamed sources report rumors, and even though the juror denies it and the defense objects, the judge dismisses the juror anyway without ever getting any evidence or any other information about it. Compare this to what we've seen in other cases. The main one that comes to mind is obviously going to be Alex Murdaugh's trial. Now, it's almost as if this were inspired by that situation. There was a juror who was dismissed right before closing arguments, just like in this case, for improper conversations outside of the courtroom, just like in this case. So it's pretty much the same situation, right? But now let's compare how it was handled. Judge Clifton Newman said he received a letter from a member of the public who said that the juror had talked about the case outside of the court and gave her opinion on evidence. So what did he do? He had the individuals and the juror interviewed by investigators. He also received evidence of the accusations before deciding to dismiss her. He also had a closed-door hearing in chambers. He put a lot of time into finding out the truth of what had been reported. What did Judge Canoni do? None of that. Not even one thing. And that is the main issue here. But that's not the main issue that the Commonwealth wants to talk about, and it's not what the judge is mad about. Let's start with the judge. The hearing began on March 5th with Judge Canoni wanting to ask Attorney Alan Jackson about his motion for dismissal, where he states that Lieutenant Fanning had control over and access to the jury.
So the fact, what you state is fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
So Jackson begins trying to answer her, but he can barely get a word out without Judge Canoni cutting him off and interrupting him. Now, I'm not going to bother with clips because it's too choppy to even make anything out because she won't let him speak a full sentence. Eventually, Jackson is able to get out what he's trying to say, and he explains that during the sidebar with the jurors, rumors being brought up, Assistant DA Miss McLaughlin told them about Fanning's role.
During that discussion at sidebar, that's when Miss McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that he has...
I'm just going to stop you. I'll let you finish in a minute.
So Jackson explains that when McLaughlin told them Fanning's role in this, it led them to believe that he had access to or control over the jurors in some capacity. Now, I have to say, it would have been nice to see this same energy from the judge on any of the Commonwealth's plentiful transgressions, but that never happens, and it's one of the things that makes this case feel increasingly more difficult to witness. The same energy and reactions are not applied to both sides. Even when Brennan gets up and says things that are absolutely false, there's none of this energy. There's no repercussions. So, Judge Canoni is mad. She's mad about the defense saying in their sworn affidavits that Fanning had access to the jury. Now, Jackson points out that the defense asked Judge Canoni to have evidence on this and to get more information, and she flat out denied them. So he had to rely on his reasonable conclusions since she wouldn't bother getting any facts. Jackson also calls the dismissal of the juror wildly inappropriate. Jackson says that they didn't hear anything from anyone about Fanning not having access to the jury until Brennan filed the opposition. But, Brennan says a lot of things with no evidence or affidavit to back it up, and he's often wrong. Brennan has the credibility of a tabloid magazine, so it's hard to take his word for anything. But that doesn't seem to bother Judge Canoni.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I take the court at its word, obviously, clearly.
We will move on from that, Mr. Jackson. We'll move on from that.
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror. and knowing at the same time that he was intimately involved in the prosecution of my client, that's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report.
Judge Canoni doesn't want to hear anything that Jackson is saying. She says move on, but they don't want to move on. They want answers. Why not have people under oath explaining what happened, and why not get evidence of this? How did somebody know to tell Fanning about a juror? And how are they able to identify which juror it was? And how was Fanning able to tell a court officer which juror it was, if he was never around the jurors? Don't you think that's important to find out before dismissing a juror? And also, where was this energy when Brennan was up there for 15 minutes explaining how they withheld evidence from the defense in the first trial, all while making a mess out of everything because nobody did their jobs? She didn't say, I'm not satisfied with this. I'm not satisfied with your answers. This was how she responded to that when it was over.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with...
So, Brennan also wants to address what he refers to as the jury tampering in the most dramatic and self-righteous way possible. Brennan talks about this being one of the most serious claims that one can make, and it questions the fabric of our entire judicial system. If jurors believe that there's no integrity, it's impossible for them to consider evidence because they don't trust the system to begin with. Now, you'd think that if Brennan cared about jurors trusting the system, he himself would try a little bit more to be trustworthy. After all,
a lie unchecked becomes the truth.
So, Brennan accuses the defense of finding a willing partner who covets an opportunity to meet with the defendant. Now, he's talking about the Ted Daniels interview here. He says that they find time, like after the Super Bowl, so that they can get national exposure and then seep information into the public and let it resonate. He also says it's not insignificant that this same information about the jury tampering was being disseminated by Aidan Carney, aka Turtle Boy, before this interview. Which, by the way, that was last August. So Brennan says that in the interview, Jackson is asked about unsubstantiated rumors of jury tampering and asked if it's a concern. So Jackson says he's never just dismissed the thought because it was all too convenient, but he doesn't have any specific evidence of jury tampering. Now, Brennan says that Jackson said in the interview that he didn't have any evidence of it, but then he filed this motion. Jackson says that this motion is requesting an evidentiary hearing on that because the defense was denied an opportunity to get any facts on that by the judge. So then, Brennan moves on to Fanning. So, look, here's the deal with this. Brennan says basically that the defense used the Ted Daniels interview to get this information out there. And then they had to pick a target of who to blame. So they picked Fanning. Now, the problem here is that they didn't pick Fanning. Jackson says this was specifically told to them at sidebar that Fanning was the one who brought the unnamed source rumors, and Miss McLaughlin is the one who told them his role and his title. They didn't pick Fanning. Fanning was dumped into their laps at sidebar. Then Brennan starts fangirling over Fanning.
And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired.
So let me set the scene for those of y'all who missed it. This pause right here is because as soon as Brennan starts to say that Fanning is so admired and amazing, Karen Reed turns around and makes a face. Now, it looks like she's looking at one of her family members sitting behind her. And Brennan sees her and stops speaking and stares at her. Look, I'm not going to lie. I made the same face when he started fangirling. I don't know Fanning as one of the most admired and conscientious dudes ever. I I know him as the lead investigator into Sandra Birchmore's death, where he put on his affidavit that based on the evidence, it was a suicide, when it was obvious from the evidence that it wasn't. And I know Fanning from a case from 2015, where he and Colleen Crawford, who we talked about with all those Sallyport video issues, were accused of tampering with video evidence. Now, according to those court documents, Fanning and Crawford went to a location to collect video surveillance, but Crawford was unable to retrieve the video. So it was determined that she would just need to take the whole video system as evidence and perform a forensic video analysis on it at the Norfolk County DA's office. So the bulk of this unedited video is taken by Fanning and Crawford to the DA's office, and court documents say that the videos were heavily edited by the DA's office. Now it reads, quote, "This means that the records were curated rather than raw, generating questions of accuracy," end quote. Sounds familiar, right? Kind of like 6-hour segments somehow getting curated into a collection of really bad clips. So the defendant in that case was convicted, but the conviction was vacated because, you guessed it, prosecutorial misconduct. The prosecutors from the Norfolk DA's office crossed all kinds of lines. Now, the defendant punched and stomped a man at a Quincy bar, and the man died from the injuries. The prosecutors wanted a murder conviction instead of an involuntary manslaughter. So they said a bunch of stuff that wasn't true and had no basis in fact in order to make the circumstances surrounding the incident worse to secure a murder conviction. They were also mocking the defendant's defense, telling the jury to cast aside their ridiculous notion that the defendant did not do whatever it was they said. Now, it sounds a lot like Morrissey telling the jury pool that the defense's theory is a desperate attempt to reassign guilt. What is in the training manuals around that place? Now, after that conviction was overturned for prosecutorial misconduct, he was retried without the lies and convicted of involuntary manslaughter. There seem to be a lot of patterns around here, no? Now, Fanning and Crawford also owned a business together called Expert Data Analysis LLC, which is obviously going to raise some eyebrows when you consider that both of the cases that we've discussed that they worked on, this one and Sandra Birchmore's death, both had multiple issues with data analysis. And the one that I just mentioned had data analysis issues. Like I said, there's a lot of patterns around here. And Karen Reed is incredibly involved in her defense. So hearing Brennan praise Fanning so highly, ignoring all of these other cases and all of these other issues, that's bound to get a reaction. And Brennan paused twice to have a stare down with Karen. Now, everyone will perceive that differently. To me, it looked like the prosecutor couldn't control his own emotions and he looked like he was trying to intimidate her. Some others may perceive it differently, but if I were him, I wouldn't try that in front of a jury. So Brennan continues his sentence after this first stare down, and then he pauses to stare her down again in the middle of the next sentence, and then he finishes his praise of Fanning. Now, I'm cutting out the second pause here just so we can get through the clip.
State police officers in Massachusetts, after having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened.
Okay, so Brennan is very angry about social media being very angry at Fanning. Now, this has literally nothing to do with the defense's motion. Nothing. Anything said on social media about Fanning has nothing to do with the defense or their motion. But Brennan isn't big on facts. Now, normally I like to point out all of his wrong information after I've played what he said, but this one is so over the top and dramatic that it's much more enjoyable when you listen to it knowing that he's wrong. Now, Brennan is about to tell Judge Canoni that the defense put in their motion stuff about Fanning and how he was investigated in connection to this case. So he tells the judge to look at the bottom of page 15, and it comes across like he's trying to tattletale because he even basically tells the judge, see, this is why I told you we need to redact their motions. They're putting this in here so that they can smear his name. But as you listen to this, it's important to know that what he's reading from the defense's motion, the defense had completely redacted. They did not put this out to the public. That is actually what Brennan is doing himself right now.
When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline.
And Brennan's about to double down on this, again telling the judge completely false information. Fanning's name is not mentioned even once in the public document. His name is only mentioned in the unredacted document to the court that the public does not have access to.
They put this in a public document. They tried to smear him, degrade, demean, dehumanize.
So Brennan says that the defense left off the internal investigation into Fanning, concluding that these complaints were not sustained. And all that means is that there isn't evidence that can prove or disprove the complaint, so the investigation is over. Now, in the defense's motion, not one time do they mention Fanning, and they completely redacted every part of anything about Fanning for the public. So I can only assume that their argument here to the court was to discuss Fanning's involvement in the case and with Proctor and whoever else. So in this case, it wouldn't be necessary to make sure that the court knows that there wasn't enough evidence to prove or disprove anything in the investigation, because that wasn't really the issue. But Brennan isn't a truth teller. Facts don't work in his dramatic monologues. And also, there are 4 categories of what could happen. So 1 is unfounded, which means the complaint did not occur. 1 is exonerated, which means it happened, but it was justified. There's sustained, which means the complaint is supported by evidence and disciplinary action is justified. And then there's the not sustained, which means that there was no evidence either way, which is what they decided here. Now, it is ironic that he is clutching his pearls so hard over the information about Fanning being made public when he himself is the one who is discussing Fanning publicly, not the defense. Brennan continues on with his pearl-clutching false narrative about the defense. Now remember, all of this is based on Hank telling the judge that the defense is telling this to the public when they completely redacted it.
And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously.
So now, Brennan moves on to another false narrative. Now, the defense never said one word about any of the court officers, but Brennan is up here trying to create enemies and get people all riled up. It's a ridiculous attempt by Brennan that I'm not even going to waste time on. Jackson clears it up when he gets up to rebut, pointing out Brennan's dramatic use of facts with no evidence to back any of it up, and his use of half arguments. He also points out that his whole speech about the defense naming Brennan was wrong because they redacted all that. Now, Brennan is the one who brought Fanning into the public here. Jackson also brings up the fact that this is the Commonwealth's pattern at this point. They get up there, they say all these things that aren't in the motion, and just throw stuff out there as fact when it isn't. It gets old. WBZ reporter Christina Rex spoke to a juror after this wild hearing, and the juror released this statement. Quote, "I was a fair-minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. It is the Reed case itself, and the fact that it is still being brought, that has left many in Massachusetts wary, distrustful, and scared of our system. As a lawyer, this reality saddens me even more because I remember how much faith I had in our system as an optimistic law student." Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the, quote, fabric of our entire judicial system, end quote. If he truly would like to address that problem, I have a few suggestions. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayer dollars prosecuting a case with so many evidentiary issues that it calls into question whether they are even following their ethical obligations as prosecutors. The Commonwealth has a duty to protect the rights of defendants, and I, for one, would love to see them do so. End quote. Now, this juror is a lawyer, so it's really interesting to hear her perspective. And it's very telling that this case and the prosecution has had so many issues that the faith that she once felt for the system that she loved has now been replaced with distrust and fear of the system. I'm afraid that with the way that Brennan is handling this case, that distrust will only get worse. So, what's up next? The federal judge has denied Karen Reed's petition for habeas corpus. Karen has already received her certificate from Chief Judge Saylor that will allow her to appeal that. It's also the deadline for all the motions and responses this week, and holy moly are there a lot of them. Now we're back in court on Tuesday and Wednesday, the 18th and 19th, and some of these motions should be argued. I'll have a breakdown of all of that in the next episode.
My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.